Hold on, I got to sneeze.
Mm-hmm.
All right. Ready?
Yep.
Here we go. 3, 2. Good morning, everyone. Today is Tuesday here at 10 a.m. on the Bottle Business Sense Show. I want to welcome everyone back to the show today. And if you're a new viewer, welcome. We are a best practices simulcast where we speak about best practices from a legal aspect, how to protect your business, or on estate planning, as well as marketing topics. And today we have a great episode here for Bill that he's going to share about distribution agreements. And but before we get into that, you can always reach us on social media, Google Plus, Twitter, Facebook. And for those of you that want to contribute feedback or even be a guest on the show, go ahead and drop us a line at bottlebusinessshow@gmail.com. We'll be happy to entertain your topic.
And thanks everybody for tuning in. We're going to do something a little bit more broad than just distribution agreements. Really, distributors, what they are, who they are, how important they may play in terms of the role they may play in terms of your business. And then from there, just some of the general points that you need to be aware of, which would also incorporate the various things that you need to be incorporating into an agreement should you choose to do business. But, this show, the reason we're doing this topic on this show today is because this is becoming more and more prevalent in the business world, where you're able to utilize a distributor for a number of different reasons. I just got a call the other day from somebody who was inquiring about a distribution agreement and the role of a distributor and how that may come into play with regard to independent contractors and employees, and how you cover all the bases, and how they want to expand into different states and be able to utilize distributors, and what's the advantages and disadvantages versus just opening up another store and hiring more employees, that sort of thing. So there are of numerous ways in which manufacturers or owners of products or services arrange to have those things sold to the public. And we all know the basic ones, right? You may decide to do it in-house, by which you have outside and inside sales personnel selling the product or service. You may decide to use a franchise. You may want to sell a franchise, like McDonald's, for example, and open up a business that way. Or you may seek to just simply sell it over the internet. But by far the most common method that businesses utilize are distributors, who are normally independent entities, independent contractors, who they pay their own expenses. They buy the product from the manufacturer for purposes of resale. They may simply process orders, or they may directly ask you to purchase from the manufacturer and receive a commission for their efforts in getting the purchaser to contact the manufacturer. Or, as I said, they may just simply purchase product from the manufacturer and then distribute it on their own as independent contractors. So, and then they would be paid accordingly, and we'll get into that in a minute. But why would somebody want to do this? Why would a startup company, for example, Rick, want to, a startup manufacturing company, let's say, want to avoid the cost of setting up their own distribution? Well, you're starting up a company, right? You're going to have sales personnel, computers, supervisors, materials. You're going to have to incorporate many expenses into the business that maybe you want to put off for a while. Maybe you're starting it up and you're just a mom and pop, or you're a one show person, and you just need some help distributing these products. And you decide you're going to go the independent route for a while and hire distributors. That's a cost-effective way of beginning business. And in fact, I would tell you that even when you're starting to prosper, many companies still find this to be the way to go to keep down additional costs that they might have otherwise. So let's look at it first from the distributor's point of view. They get access to a product line, and normally the sales materials and support needed to sell the product, right? So I'm going to sell this product for you, Rick, and I'm going to get access to your products and to all of the training that I may need from you to be able to sell these products, right? I don't have any headaches. What do I mean by headaches? What would you guess?
No,
I mean,
well,
I don't have any production headaches, right?
right.
What typically happens in a company that's developing various products? Research and development costs, right? I don't have any of that. Mm-hmm. The distributor doesn't own the product, and doesn't own the territory in which the distributor is going to distribute the product unless that's negotiated. So, these types of negotiations protect distributors from getting into trouble in having issues with other distributors who may be competitors, or with the manufacturer who may want to sell in that area as well. You may have a manufacturer who hires a distributor, right, and says, I want you to help me distribute my products, but I also want to be able to sell on my own in that territory. Well, that's going to cut down on the profit margin of the distributor, right? So depending upon the wealth of the company, how big it is, how prosperous it is at the time, depending upon the nature of the product, perhaps depending upon the size of the territory, a distributor may or may not want to do that kind of arrangement. But when all is said and done, this distributor's territory is very, 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 very important to him or her, because this specializes and of course, distributor may have more than one territory, but for the sake of this show, let's just talk about a territory. It's everything to a distributor. It's the location, right? And the type of product the distributor can sell within that location. It's an exclusive territory, because otherwise, if you have a non-exclusive territory, either the manufacturer or the agents or both can sell in that territory, and this can be disastrous because the manufacturer will without even trying, put a real dent in the distributor's business.
Right.
So it's vital for the distributor to seek a exclusive territory when he formulates a contract with a manufacturer.
Yeah, that makes total sense, because it's not motivating for a distributor if he doesn't have that exclusive area. I know back in my days in the medical field, in selling medical equipment, we frequently had distributors in areas where maybe there wasn't any local representation, and we could easily tap into a marketplace that was already established, but yet offer the product line through distributorships. And it was, like you said, is a much more cost-effective way of doing it. And the territories were well defined, so there was a lot of motivating factors for the distributor to have access to a particular product. with everything that you had mentioned.
Yeah. And so I want to give our manufacturers, because this mainly is going to do it. This can happen with a service, but it's mainly with a product. And I want to give bullet points as to what you should have included in your contract with a distributor, and what a distributor should also want in a contract with a manufacturer. And I don't advocate somebody going out and doing this on their own without an attorney, but nevertheless, are there bullet points that you need to be aware of should you decide and do this on your own, or if you have an attorney do it, you're going to want to make sure that he or she covers all these bases. So the first one we discussed, that would be territory. The second one would be terms of payment. The question you have to ask is whether the distributor must buy and resell the product, and under what credit terms, if any, you might make available to the distributor, because the new distributor should only seek, in my view, to earn a commission from sales and have the manufacturer sell directly to the customer, with the distributor merely earning a commission. This cuts out the need for the distributor to actually take possession of the product and actually ship it. Now, is there anything wrong with that? No, but it's going to cost more for the distributor, right? He or she is going to have to bear the burden of those costs, and that's going to cut into the profit that the distributor makes. So I always advocate, if I'm working on behalf of a distributor, to make sure that rather than shipping the product to me and having me distribute it, or rather having me take in inventory and hold it, which is going to require storage fees more than likely, right? Or time and effort to keep this product on hand, not to mention if it's a product that has an expiration date. I would always advocate to have the distributor earn a commission on sales that he or she can generate and have the shipping done directly by the manufacturer. Assuming the manufacturer is also selling to the customer or the consumer, the distributor must negotiate and achieve good contractual terms so that the customer doesn't end up buying directly from the manufacturer and cutting out from the distributor. So we've talked about this. You're going to have to negotiate equitable terms that are going to allow you to either purchase on credit and defer some of those costs, or better yet, have the product shipped directly from the manufacturer, where you then make a commission as a consequence of any orders that you process. Mm-hmm. You want to be able to incorporate those specific terms in a contract. The third thing I think you need to look out for is the term of the contract. A wise distributor wants to build into the contract a startup time to develop a market, right? In other words, the distributor is not going to willy-nilly go out there and say, yeah, I'll distribute your product over 5 years, when maybe the product's not going to be very sellable, or end up not being very, in hot demand. And so now you're in a contract that's going to keep you for a longer period of time than you want. So you might want to also have a period of time in the contract that allows you to back out of it after a kind of a probationary period, if you will, able to market. And in order for you to be able to establish your market from the standpoint of potential customers, which, and a lot of this is just basic common sense, but it's important. So the term of the contract would be important for both parties, because you don't want to end up as the manufacturer with a long-term distributor who's really not going to be giving you much benefit, even though you may not have to pay the commission until the product's sold. What if you have a contract with somebody who takes on your product, and now you got half your inventory with a distributor who's not moving it? Right. So these are things that really, really are important. Of interest, and I think this issue came up for me a while back. At a minimum, the distributor should seek a 3-and-3, it's called. That is a guaranteed non-cancelable contract for 3 years, which is renewed for 3 years if all criteria are met. So I advocate that once this probationary period is over, once the distributor has established his market, or her market. And it may already be an established market. I'm talking about somebody who's got to go in and do that. Then you're going to maybe want to have a term of 3 years where it can be renewed for 3 years as well if all of the terms and conditions of that contract that you set forth are met. Then you got a renewable contract, you're good to go, and you got a good business relationship with the manufacturer. Another point would be cost of sales, because the distributor should, he or she needs to review the likely need for materials like web support and things of that nature. So if you are going to do more than just sell on commission, you're going to have to incorporate the cost of that sale that it's going to take you to distribute that product, and you're going to have to make sure that that's covered in the contract. So real important stuff. And I think I could talk about this for a couple of shows, but I think what I'll do from here on out is highlight the points that need to be covered in the contract, and cost of sales was number 4. Number 5 would be, what about return goods? What if you have to have goods returned? Who's going to bear that cost for defective goods, or for somebody who just says after a trial period, if you provide a trial period, I just decided I don't want the product. You've got costs of return goods. You've got maybe training stuff that you want to distribute. That's going to have to be taken into consideration from a manufacturer's standpoint. How much commission am I going to pay somebody by providing him written materials, by providing him or her training, by having to take back return goods? These are all important stuff that you can see probably is going to be juggled between the distributor and the manufacturer. These are things, in other words, that both parties need to be worried about, not just one versus the other. Number 6 would be competing products. Most manufacturers want undivided loyalty from distributors and will insist that no competing product may be sold by that distributor. Manufacturer is going to want in the contract, right? Because you're going to want to make sure the distributor is not willy-nilly selling not just his product, but another product by another manufacturer who competes with the first manufacturer. All real important stuff. And finally, number 7, you want to have a severance protection built into the agreement. Either the manufacturer will go in-house at some point in time, or there's going to be an end to the contract that I mentioned before. There can be an overlap where I mentioned the 3 and 3, the 3 years. But some contracts provide for an endless term, and you're going to not want to do that. A critical factor is what happens to sales already booked upon termination. Is the distributor going to get credit for those sales upon termination of the contract that hasn't actually been sent to the purchaser yet? Or is the person going to get credit? Is the distributor going to get credit for those sales upon writing up the order? Period. End of story. Is that the triggering factor that pays the commission? So these things have to be covered in the distributorship agreement, and really are important. Standard contract terms that are in every agreement. And those would be whether you want to have forego legal action in a court and have binding arbitration, whether you want to have mediation, whether if you have a defective part of the agreement, it can be severed from the totality of the agreement, therefore allowing the rest of the agreement to stay in place. What state law is going to control the agreement. Those are all things that I refer to as standard terms, and there's quite a few of them, and those need to be referred to in the agreement and really should be done by a lawyer. So you can see, I think, that there's a lot to this distributorship issue, but if you do it the right way, it can be done very succinctly and very clearly, so it benefits both parties.
Let me pull up another point. Like I said, in my experience, I was part of the alternate distribution channel for a medical device, and speak to us about product warranty. How do you recommend that be handled?
Well, the product warranty is typically handled by the manufacturer. Now, interestingly enough, under products liability law here in California, if you have a distributor or somebody who's distributing the product that's manufactured, let's take Costco. Costco is a wholesale warehouse distributor, right? You go into Costco, you could buy all different things that are manufactured by all different companies. So if you have a defective product and it causes you injury or damage, you can sue the manufacturer and the distributor as a result of that defective product. So you're going to want to be able to discuss how you're going to set up any indemnification issues in that agreement. And that would be where mentioned at the end, standard terms of a contract. You're going to want to include that issue within standard terms. And it's a very important point. I'm glad you brought it up, Rick. It's an issue that can be dealt with in a number of different ways, depending upon how the manufacturer or the distributor agree. Manufacturer might say, I'm giving you this really great product. It's hot. I'm giving it to you exclusively. But if something happens, you're going to have to indemnify me. On the other hand, the distributor may say, hey, I'm taking a risk here. It's a brand new product, brand new territory. If something happens and I get sued, I want you to indemnify me. Mm-hmm. So a lot of variables go into play there in a situation like that, but without question, that needs to be covered in the contract and negotiated out beforehand.
Right. I know in our situation, we also extended the out of most of the products were guaranteed for a year, right? Or covered for a year as far as service and that sort of thing.
Oh, so you're talking about a warranty of service as opposed to a defect. Okay.
Sure. Let's talk about maybe just touch on like a service contract that's provided by the manufacturer that is also offered as a separate line item to the distributor.
So you're going to warranty how long that product is going to work. In other words, if you want to put it in simple language, how long it's going to be good for. And that generally will be assumed by the manufacturer, because a distributor is not going to want to get involved typically in warranting a product in terms of its effective usefulness. The first issue I talked about, where you have indemnification, that's if somebody gets injured from using the product, physically injured, mentally injured, however it may be. But for general warranty usage, use warranty, that's going to be typically assumed by the manufacturer, because the distributor doesn't typically have any control over how good or how long that product's going to work for. That's not to say that it can't be negotiated by the two if the distributor is willing to take more of a risk, again, depending upon how some of the factors in the forefront are going to be beneficial. It might be a situation where the distributor doesn't want to pass this up and he's willing to take on some risk like that. But typically, use warranties are assumed by the manufacturer, because they're the ones that are making the product and really are the only ones that can say how long it's going to be useful for. So a lot of different variables, Rick. And I hope this points out two things: why distributors are so important in business today and why they're used so frequently. And number two, why it is so very, very, very important to see a lawyer to do these contracts. This is not something you should be doing online by yourself.
Well, there you have it. You heard it straight from the horse's mouth. If you are in a situation where you are distributing services or products like we discussed here today, someone like Bill is an expert in that area. You want to reach out to him and get some clarity, get some definition, and get protected in the case that you are expanding through distributorship. So, Bill, why don't you share your contact information with our listeners out there?
Yeah, and both numbers are 949, office number 698-6222, direct line 413-6535, and of course, Bill at wfblegalconsulting.com is my email. But I wanted to point out one other important issue for everybody before we go, and that is, we talk on this show about business entities formation, which is a form of asset protection. We talk about estate planning in our last show. We talk about employment issues, like we're talking about here in this show, sometimes very directly, sometimes between two different companies. But in effect, and independent contractors, again, like we're discussing in this show, in effect, that encompasses a business practice for a good business lawyer. It's who you should have on board for your company. The reason we can talk about all these things is because every single thing underlying all of those areas of law that encompass business practice are all founded upon contracts. And that's what a good business lawyer should profess to be and enjoy doing, which I do. I'm also a litigator and have a great deal of litigation experience. That's just an added benefit for my clients in case they do get into trouble and have to walk up the courthouse steps, which of course we try to prevent. But back to contracts. Contracts is the underlying foundation. A living trust is a contract. Any kind of an employment agreement is a contract. A distributorship agreement is a contract. A operating agreement for an LLC is a contract. These are all contracts, and that's what your business lawyer has to be proficient in. So I hope that I hope our entrepreneurs and business owners can carry that with them when they listen to these shows, because I think that's extremely important to understand.
Yeah, that's great advice. So, folks, if you are in need of any business contracts, estate planning, entity creation, please reach out to Bill. He's great. He'll entertain your call if you just want to get some general information, and you can reach him at the contact information below this video. So again, Bill, thank you very much for the topic today. We look forward to hearing more in the episodes to come. So,
not a problem.
So thanks for joining us, everyone. We will see you in another couple of weeks here in April. Everyone have a great week. Have a prosperous week. And we will see you on the next episode here on the Bottled Business Sense Show.
That's right. Take care, everybody. All right.